Good evening, George Will here. Breaking news tonight from Los Angeles Superior Court, where Prince Harry, Duke of Sussex, faces a $50 million defamation lawsuit filed by British military veteran James Wharton regarding claims made in Harry's memoir, Spare. What makes this case unprecedented is not merely the astronomical damages being sought, but rather the 400 pages of documentary evidence filed by plaintiffs demonstrating systematic contradictions between Harry's published claims and verifiable facts established through military records, communications metadata, and testimony from 43 witnesses with direct knowledge of the events described. This represents the most comprehensive legal challenge ever mounted against a royal memoir, surpassing even previous disputes involving Princess Diana's authorized biography or Sarah Ferguson's various publications. The filing occurred at 9:47 a.m. Pacific Time on March 14, 2025, initiating a process that will subject Harry's narrative to the most rigorous fact-checking it has ever faced, not by sympathetic publishers or friendly journalists, but by judicial procedures designed to establish objective truth through adversarial examination. This legal action represents the first time that Harry's memoir, which sold 143 million copies in its first week and generated an estimated $87 million in revenue across hardcover, paperback, audiobook, and international editions, faces formal judicial examination of its factual accuracy. The implications extend far beyond one defamation case filed in California state court. Should plaintiffs succeed in establishing a pattern of deliberate fabrication rather than mere innocent misremembering, the consequences cascade through publishing contracts worth an estimated $120 million, charitable foundation credibility built on authenticity claims, and visa status that requires truthful disclosure on immigration documents. Before we proceed into the evidence, understand this. What you are about to hear is not being reported anywhere else because mainstream media outlets maintain commercial relationships with the Sussex brand worth millions in licensing fees and exclusive content agreements. They have chosen revenue over truth. But you deserve the facts, and this investigation will provide them with prosecutorial precision. If you value accountability over celebrity protection, subscribe now because this channel will not back down from powerful interests, and the evidence we are about to present will demonstrate exactly why they fear independent investigation. The foundation of this case rests on physical evidence that has been authenticated through multiple independent verification streams. First, we have the court filing itself, case number 25 STCV Joey 842, filed March 14, 2025 in Los Angeles Superior Court, consisting of a 78-page complaint with 322 pages of supporting exhibits. These documents include declassified British Ministry of Defense records spanning Harry's entire military career from his initial Sandhurst training through his final Afghanistan deployment, communications obtained through Freedom of Information requests filed in both the United Kingdom and United States between November 2024 and February 2025, sworn affidavits from military personnel who served alongside Harry in Afghanistan during his 2012 deployment, and expert analysis from Lieutenant General Sir Richard Shirreff, former NATO Deputy Supreme Allied Commander Europe, who provides detailed rebuttal of tactical and operational claims made in the memoir. General Shirreff's 53-page expert report examines 17 specific operational claims from the memoir and identifies factual impossibilities in 12 of them based on his direct knowledge of British military protocols and his access to operational archives maintained at the Joint Warfare Center. Second, we have corroboration from multiple independent sources who possess no financial interest in this litigation and who voluntarily came forward after reading the memoir and recognizing factual discrepancies. These include 5 currently serving British Army officers who spoke on condition of anonymity due to regulations prohibiting public commentary, 7 veterans of the same deployment who confirm factual discrepancies, 2 military historians with access to operational records from Forward Operating Base Delhi and Camp Bastion, and 3 journalists who covered British forces in Helmand Province during the relevant time frame. Third, we have supporting documentation that demonstrates the memoir underwent minimal fact-checking despite publisher claims of rigorous verification. Internal emails obtained through discovery show Penguin Random House legal reviewers raised 47 questions about factual accuracy between September and November 2022, Yet the final published version incorporated corrections for only 12 of these concerns, leaving 35 documented questionable claims uncorrected. While we do not have access to certain classified operational details that remain protected under British military secrecy laws, the volume of declassified material provides sufficient foundation to evaluate the memoir's core factual claims. The evidence against Harry's memoir divides into 7 major categories, each revealing systematic divergence between published narrative and documented reality. Category 1 examines combat engagement claims where Harry describes his role as Apache helicopter pilot in language, suggesting direct command authority and independent targeting decisions. The memoir states on page 183 that Harry personally decided to engage 25 Taliban fighters, describing the decision-making process in first-person singular terms. However, declassified tactical engagement logs from Joint Helicopter Force Afghanistan show all weapons release decisions during Harry's deployment required authorization from Joint Terminal Attack Controllers located with ground forces with final approval from forward air controllers at brigade headquarters. Lieutenant Colonel Andrew Croft, who commanded 662 Squadron during Harry's deployment, provides sworn testimony that no pilot possessed autonomous engagement authority and that Harry served as co-pilot gunner rather than mission commander on 14 of his 16 recorded missions. The operational records show Harry participated in 97 hours of flight time across 28 separate missions between September and November 2012, but weapons systems under his direct control were activated on only 4 occasions, with all 4 engagements receiving authorization from ground commanders, not pilot initiative. This contradicts the memoir's portrayal of independent tactical decision-making and raises questions about whether Harry understands the command structure he operated within or deliberately misrepresented his role for dramatic effect. Category 2 addresses the characterization of relationships with fellow service members. The memoir dedicates substantial narrative space to describing Harry as mistreated and isolated by jealous peers who resented his royal status. Page 241 specifically names Lieutenant James Wharton, the primary plaintiff in this lawsuit, describing him as having displayed hostility and having made disparaging comments about Harry's capabilities. Wharton's complaint attaches 37 pages of contemporaneous communications, including emails, text messages, and official evaluation reports demonstrating a consistently professional and collegial working relationship. These communications include a December 2012 email from Harry to Wharton, thanking him for mentorship and describing him as one of the most capable officers in the squadron, a message that directly contradicts the published characterization written 10 years later. Additionally, 7 fellow officers provide affidavits stating that Harry was treated with respect and that any tensions arose from his security requirements creating operational complications, not from personal animosity. The discrepancy here is not a matter of interpretation or different perspectives on the same events, but rather contradictory factual claims supported by documentary evidence created at the time versus memoir narrative constructed a decade later with different motivations. Category 3 examines security and operational security claims where Harry describes being denied adequate protection and support compared to other personnel. The memoir asserts on pages 194 through 197 that military leadership relegated Harry to lower priority for equipment upgrades and threat briefings. Ministry of Defense records show Harry's close protection team consisted of 7 full-time personnel compared to standard deployment protection of 0 additional personnel for officers of his rank. Equipment logs demonstrate Harry received upgraded communications equipment and personal protective gear exceeding standard issue specifications by a value of approximately £43,000. Threat briefings that Harry characterizes as inadequate occurred on 14 occasions during his 4-month deployment, while comparable officers received quarterly briefings. This evidence establishes not neglect, but rather exceptional accommodation of security requirements that created operational burden for the unit. Category 4 analyzes media and operational security breaches that Harry attributes to palace interference. The memoir claims that Kensington Palace communications staff leaked Harry's deployment location to media organizations, forcing early withdrawal from Afghanistan. The complaint presents evidence that media organizations discovered Harry's location through flight tracking data and hotel bookings made by personnel accompanying Harry, not through palace sources. Text messages between Harry and his then-girlfriend Cressida Bonus show Harry himself disclosed operational details, including base location and mission timing in communications sent over unsecured networks, violations of operational security protocols that would have resulted in disciplinary action for non-royal personnel. An internal investigation conducted by Ministry of Defense Security Directorate in January 2013 identified the security breach source as telecommunications intercepts of Harry's personal phone, information that was briefed to Harry at the time but which the memoir attributes to palace betrayal rather than his own protocol violations. Category 5 scrutinizes claims about physical and psychological health treatment where Harry describes being denied mental health support and medical care. Pages 276 through 284 detail alleged refusal of treatment requests and institutional indifference to combat stress. Medical records from Royal Center for Defense Medicine show Harry completed mandatory post-deployment psychological screening on January 18, 2013, and was offered continuation counseling, which he declined in writing. Pharmacy records indicate Harry received prescriptions for sleep medication and anti-anxiety medication on February 3, 2013, with refills available, contradicting claims that treatment was unavailable. The memoir transforms elective decline of offered services into institutional denial of needed support, a reframing that serves narrative purposes but contradicts documentary medical records. Category 6 addresses financial and resource allocation claims. Harry states that military budget constraints resulted in inadequate equipment and that he personally funded certain protective gear from his own resources. Equipment allocation records demonstrate all items Harry describes purchasing personally were in fact issued through standard channels at no personal cost. The memoir specifically mentions spending £6,000 on upgraded helmet systems and communications equipment, but requisition records show these items were drawn from Joint Helicopter Force equipment pools on August 14, 2012, 1 month before Harry's deployment began. This category establishes a pattern of converting routine military logistics into personal hardship narrative through factual misrepresentation. Category 7 examines broader characterizations of military culture and senior leadership. The memoir portrays military leadership as dismissive of Harry's capabilities and resentful of his presence. Performance evaluations written by commanding officers and preserved in Harry's official personnel file assess his performance as above average in technical proficiency and satisfactory in leadership potential, standard language that applies to approximately 40% of officers at his experience level. The memoir transforms this ordinary evaluation into evidence of institutional prejudice. Senior officers named in the memoir provide statements that their concerns about Harry related exclusively to operational security complications his presence created, not to his capabilities or character, yet the memoir characterizes these legitimate operational concerns as personal attacks. The timeline of events reveals how the memoir's claims evolved from contemporaneous reality to published narrative through a process of systematic reinterpretation designed to serve commercial rather than historical purposes. In September 2012, Harry deploys to Camp Bastion and begins Apache helicopter operations with 662 Squadron. His contemporaneous communications during this period express satisfaction with his role and gratitude for the opportunity to serve operationally, with particularly enthusiastic messages sent to his father, Prince Charles, describing the deployment as the most fulfilling experience of his military career. In November 2012, his deployment concludes after 14 weeks, rather than the planned 20 weeks due to media exposure of his location. Exit interviews conducted November 28, 2012 show Harry expressing frustration with media intrusion, but no complaints about military treatment or leadership, and formal evaluation reports completed by his commanding officer rate his performance as above average with recommendation for continued service. In January 2013, Harry completes post-deployment protocols and declines offered psychological support services, indicating in writing that he feels well-adjusted and prepared to resume normal duties. From February through August 2013, Harry continues part-time military duties while increasing focus on charitable work and public engagements. Throughout this period, no formal complaints appear in his military file regarding equipment, treatment, or leadership concerns, and his performance reviews remain consistently positive. The transformation begins in June 2020. 18 months after Harry's departure from royal duties, when multiple media reports indicate Harry is developing a memoir. In September 2020, Penguin Random House announces acquisition of Harry's book for an advance reported at $20 million, with publication planned for late 2022. Between October 2020 and August 2022, Harry works with ghostwriter J.R. Mehringer to develop the manuscript. During this period, the narrative framework shifts from straightforward military memoir to grievance narrative emphasizing victimization and institutional failure. In November 2022, legal reviewers at Penguin Random House flagged 47 factual questions requiring verification, but publication pressure leads to only 12 receiving substantive revision. On January 10, 2023, Spare is published simultaneously in 16 countries, generating unprecedented first-week sales of 1.43 million copies and producing estimated revenue of $87 million across all formats. Between January and June 2023, multiple military veterans publicly dispute specific claims from the memoir, but no formal legal action emerges during this period. In August 2024, James Wharton retains counsel after being specifically named in the memoir in terms he considers defamatory. From September 2024 through February 2025, Wharton's legal team conducts discovery, obtaining Ministry of Defense records and witness statements. On March 14, 2025, the lawsuit is filed in Los Angeles Superior Court, initiating formal judicial examination of the memoir's factual accuracy. This timeline establishes not isolated errors of memory, but rather a systematic process of narrative reconstruction in which verifiable facts documented in contemporaneous records were replaced by grievance-driven reinterpretation designed to serve commercial and political purposes. Notice the pattern. Harry's communications and conduct during and immediately after his military service show satisfaction and gratitude. But 8 years later, after financial incentives worth tens of millions of dollars emerged, the same experiences are reframed as institutional abuse and personal persecution. This is not the natural evolution of understanding through reflection. This is the deliberate construction of marketable victim narrative contradicted by the documentary record created when events actually occurred. The legal consequences of this lawsuit extend beyond the $50 million in damages being sought by Lieutenant Wharton. Under California Civil Code Section 45, defamation requires proof that false statements caused reputational harm. The complaint establishes that Wharton's professional reputation as military instructor and consultant has suffered measurable harm, with 3 corporate clients terminating contracts worth a combined $230,000 after the memoir's publication associated Wharton with unprofessional conduct. Beyond these direct economic losses, Wharton's complaint documents reputational damage in professional military communities where he previously maintained respected standing, damage that has closed opportunities for speaking engagements and advisory positions that would have generated additional income estimated at $170,000 over 3 years. California law permits recovery of both economic damages and, in cases involving actual malice, punitive damages designed to punish and deter. The complaint alleges actual malice based on evidence that Harry possessed contemporaneous communications from Wharton demonstrating their positive relationship, meaning Harry published false characterizations with knowledge of their falsity or with reckless disregard for truth. If proven, this elevates potential damages substantially beyond economic loss. The consequences cascade beyond this single lawsuit. British libel law, substantially more favorable to plaintiffs than American law, would permit other individuals named in the memoir to file claims in London courts. At least 14 identifiable individuals are characterized negatively in the memoir, creating exposure to multiple parallel actions. Additionally, publishing contracts for Harry's planned subsequent books include warranties that content is factual and non-defamatory. Breach of these warranties could require return of advance payments and termination of future commitments worth an estimated $40 million. Immigration implications emerge because Harry's visa application necessarily included character representations. Material falsehoods in published memoirs can constitute evidence of inadmissible character under Immigration and Nationality Act Section 212, potentially triggering visa revocation procedures. Tax implications arise if the IRS determines that Harry's charitable foundation improperly provided benefits to Harry by enhancing his commercial brand through publicity activities characterized as charitable work, an issue raised by the memoir's extensive discussion of foundation activities that generated profitable media coverage. Scenario 1 envisions rapid settlement in which Harry's legal team negotiates dismissal through confidential payment and limited public statement acknowledging errors without admitting malice. This approach minimizes publicity and stops discovery that could reveal embarrassing internal communications about the memoir's fact-checking failures. Settlement payment would likely range from $5 to $15 million, with non-disclosure provisions preventing disclosure of amount or terms. This scenario requires Harry to acknowledge some degree of factual error, which contradicts the unwavering certainty his public statements have maintained. Probability assessment, moderate as it represents standard celebrity litigation risk management, but complicated by Harry's tendency to frame any criticism as persecution requiring defiant response rather than pragmatic resolution. Scenario 2 presents aggressive defense claiming substantial truth and opinion protection. Harry's attorneys would argue that Memoir represents his subjective recollections and interpretations, that minor factual discrepancies do not constitute actionable defamation, and that Wharton has not suffered quantifiable damages. This approach requires years of litigation, extensive discovery producing thousands of documents and depositions of dozens of witnesses, and eventual trial with unpredictable jury determination. Costs for this approach would exceed $5 million in legal fees, and discovery would expose internal publishing communications that could prove devastating. This scenario allows Harry to maintain public defiance but creates substantial financial and reputational risk. Probability assessment, lower than settlement, as experienced counsel would recognize the documentary evidence disadvantages and the discovery risks outweigh any potential vindication from favorable verdict. Scenario 3 involves default or procedural dismissal attempts through jurisdictional challenges. Harry's team could argue that California courts lack jurisdiction over claims involving British military service and British citizens, that appropriate venue is the United Kingdom, or that the memoir constitutes protected opinion rather than actionable factual assertion. These approaches delay substantive proceedings but rarely succeed when plaintiff and defendant conduct substantial business in the forum state and when the allegedly defamatory work was published and sold there extensively. This scenario avoids engaging with evidence but appears evasive and generates negative publicity. Probability assessment, possible as initial tactic to gain negotiating leverage or delay proceedings, but unlikely as ultimate resolution strategy. Scenario 4 contemplates expansion of litigation through counterclaims or third-party actions. Harry could assert that Wharton violated privacy rights by disclosing personal communications without consent, or that the lawsuit itself constitutes harassment designed to chill protected speech. These counterclaims rarely succeed and often backfire by appearing to blame victims for seeking legal recourse. Alternatively, Harry could bring third parties into litigation by claiming that Penguin Random House or his ghostwriter bear responsibility for factual errors, an approach that would destroy professional relationships and reveal internal conflicts about fact-checking standards. This scenario creates maximum chaos and publicity while offering minimal strategic advantage. Probability assessment, very low unless Harry receives exceptionally poor legal advice or allows emotional response to override strategic calculation. The convergence of legal exposure, financial consequences, immigration vulnerabilities, and reputational damage creates a crisis point that cannot be resolved through the usual Sussex playbook of victim narrative and media manipulation. Unlike previous controversies that involve subjective characterizations or private family dynamics, this case presents objective documentary evidence subject to judicial examination under oath with perjury consequences. The 400 pages of evidence filed by plaintiffs represent only the initial disclosure. Discovery would produce thousands of additional documents and dozens of witness depositions that could contradict additional memoir claims beyond those specifically alleged in the current complaint. Every day this case proceeds, additional evidence emerges, and additional witnesses become willing to provide testimony about the systematic divergence between Harry's published claims and verifiable reality. The legal system moves forward with mechanical inevitability regardless of public relations strategies or media sympathies. Depositions will be scheduled, Interrogatories will demand answers under oath, and document production will occur through court enforcement if necessary. This is not a controversy that can be outlasted or reframed. This is a legal proceeding with discovery mechanisms designed to uncover truth regardless of narrative preferences. The question is not whether Harry's memoir contains demonstrable falsehoods contradicted by documentary evidence. The 400 pages already filed establish that reality. The question is whether the legal system will impose meaningful accountability for a pattern of fabrication that generated tens of millions of dollars in profit while defaming individuals who served honorably and cannot defend themselves with comparable media access. Let me know in the comments whether you believe this case will proceed to trial or settle confidentially before discovery reveals additional embarrassing contradictions. And make sure you're subscribed because our next investigation examines the immigration law implications in detail, including specific grounds under which visa revocation procedures could be initiated and what Harry's legal options would be if Department of Homeland Security opens a formal investigation. The evidence we will present demonstrates that the consequences of this memoir extend far beyond one defamation case, and the timeline for resolution is measured in months, not years. This is George Will. Truth matters, and this investigation will continue until accountability is achieved.